I will now call for argument the second case on the morning docket, 118349, State of Kansas versus Willie E. Parker.
Good morning. May it please the court. Meryl Carr-Baumann, Capital Appellate Defender on behalf of Mr. Parker. Chief Justice Lukert, may I please have 3 minutes rebuttal?
3 minutes is granted. Thank you.
Thank you, Your Honor. In early August 2015, when Kansas City, Kansas police officers took my client into their interrogation room, they knew 3 things about him pretty much for sure. They knew that less than an hour before, he had been forcibly extracted from a church by use of tear gas so that they could arrest him. They knew that my client believed he was God. And they also knew that about a week before that, my client had shot and killed his boss, Mr. Michael Zayad, in front of KU Med Center. On the day of the shooting, Mr. Zayad and Mr. Parker and a third co-worker were working as part of Mr. Zayad's medical transport company. Mr. Zayad and Mr. Parker got into a dispute about some work-related matters, about salary, about the condition of the van, and that fight very quickly, within the space of, I think, about 2 to 3 minutes, escalated from words to physical blows to eventually a shooting. And we have a little bit of a dispute with the state as far as there was video of this. There were also eyewitnesses, and there's some discrepancies between that as far as whether it was a mutual fight or whether Mr. Parker was the sole aggressor. But at the end of the day, Mr. Zayad was killed and Mr. Parker was most certainly the shooter. So coming back to that interrogation room, they walk Mr. Parker in, they sit him down, and they get him the kind of tea that he wanted to drink. And he initially says he doesn't want to sign the Miranda warnings that they hand him. And then they start to read it out loud, and he says, I don't need anybody to read it for me. I don't need to read it out loud. So they hand him the paper. He looks at it for, I think, 30 seconds, a minute. And then they just jump right into questioning him. And during that questioning, he makes several pretty inflammatory and offensive statements, such as that he would have beaten Mr. Zayad to death if he had been permitted to, and also that he was glad he was dead. And it's only after he makes those statements and towards the very end of the interview that the officer comes back and says, you refuse to sign the Miranda warnings, but you understand, right? And at that point, my client said, I understand everything I read. So the crux of this Miranda issue, of this first issue, is sort of an issue of first impression in Kansas, and it is, what do the police have to do? We know that they have to advise suspects of their Miranda rights, but what do they have to do to check to make sure they understand them? And this is new in Kansas, of course, but I think that it's a question that we can answer by just kind of going back to basic Miranda-based principles, and that is the officers have to advise, and they have to do some kind of check. There has to be some proof by the state that the defendant actually understood what was read to him. And I think a written warning, as was given in this case, is okay. As we've cited.
Well, doesn't the standard procedure of reading out loud or having the accused read them while they're reading out loud and signing is typically the way that we ensure that there's some comprehension of what the rights are?
I think that...
Isn't that kind of the safeguard? And here, the original motion to suppress complains that the standard procedure wasn't followed, and therefore there's no showing that he understood his rights. At least that's how I read the original complaint that was heard at the district court.
I believe that they argued in the motion to suppress at least that they didn't read it aloud or otherwise check for understanding.
Follow the procedure.
They didn't follow the procedures, yes.
They outlined what the procedures typically are, and they didn't follow those procedures. But that was, wouldn't you agree that's mainly that's almost all due to Mr. Parker? He took offense at someone reading something to him and said, I can read, it was almost like he took it as they were belittling him.
I think he did take it as they were. I think that's exactly right, Justice Rosen. But I still think that the state, even at the end of that, they have a duty to ask, at the very least, did you understand? I mean, that would have been a very simple question that would have, frankly, probably killed this issue on appeal.
So is that true even if they had read it to him? Are you suggesting we need to, in all cases, have some test of comprehension?
I think that in most cases, and there's a pretty good string cite put together in the brief, you read the rights, you say, do you understand these rights? You read the rights, I don't think that that's some stretch, or that this court is going to have to go back and reverse a bunch of cases or something like that if the court says that that is what the law is today, because I think that that's what's really being done and what is required by Miranda. And by the cases that flow from Miranda. And I also
I'm not
because
sure I understand your answer, because I want to make sure I do, and I want to make sure I do. So if they would follow a typical procedure, that's okay, even if you read it to me and I didn't understand 5 or 20 of the concepts that were in the Miranda, that's okay, because we followed procedure.
I think that there's certainly case law that the typical procedure, which includes at the end a question of, did you understand these rights, is fine.
Okay, so you're not asking for an extension of the law in that area? Or
I don't
you?
believe
Okay.
so, no. I don't believe so.
Just if that procedure isn't followed is where you think we need to move forward?
Yes.
Okay.
And I think even if you look at the state's case that they cite, Tompkins from SCOTUS in 2010, and that case was, first of all, it was about 10 stages down the road in habeas. The defendant had never argued that he didn't understand. That wasn't really an issue in that case. But in that case, several times, the Supreme Court says the prosecution must make the additional showing that the accused understood those rights. So beyond reading, the prosecution does have to make some kind of showing. And I think it's pretty minimal, honestly. I don't think this is hard.
That's a substantive requirement, right? As opposed to a procedural one. Aren't we mixing those two up?
I'm not sure I understand your question, Justice Siegel.
Is your complaint that the officers did not take the procedural step of asking, do you understand? That's what it sounded like your argument was. Or is it the substantive claim that your client actually did not understand?
I think it's both. I think we don't know if he understood or not is the problem, and the state can't prove.
Why? I mean, just a minute ago you said that the substantive requirement is slight, and why doesn't your client's statement, I understand everything I read, suffice?
Well, first of all, it happened after he had already made a bunch of incriminating statements.
Why does that? That gets to my heart.
Well, I think we have case law that says you can't let the defendant come in and spill his guts, so to speak, and then give the Miranda warnings.
Well, he got the warnings before. The only thing that came after was was the confirmation that he understood his rights.
I think that is an essential part of the giving of the rights. And that's what I'm arguing today, that the rights weren't given, and maybe I am making a procedural argument under the rubric as you've set it out here, that was not a complete advisory under Miranda, under what Miranda requires, until they said, do you understand, and made sure he understood. And I don't even know particularly, and again, under the argument I'm making, I think if he had said it right after they had, if they had done the questioning at the time, they should have. I probably wouldn't have as strong of an argument here. I don't know that his answer is even necessarily perfectly responsive to the question, but given that, I think that's where we are.
Can you point us to anywhere? You read the interview. Mm-hmm. And it kind of goes all over the place, but it appears that Mr. Parker has a fairly sophisticated understanding of what's going on. He banters with the detectives, in some ways makes light of what they're doing. He says, you all the detectives, you figure it out, does that kind of stuff. So he kind of has an understanding of what's going on, describes what his activities were on the day in question. Can you point to us anywhere where you think he didn't understand what was happening or didn't understand the implication of what he was doing? I just don't see it anywhere. And I understand it's the state's burden here, but point to us where you would say that he didn't understand what was happening or he didn't understand his rights. I don't see it anywhere.
Well, and I think that's partly where his mental illness comes back into this. There are statements, and when he walked into that interrogation room, yes, he didn't have some kind of diagnosis in his hand when he walked in.
And again, you're saying the process of this, and I appreciate he had not been given a competency evaluation prior to this, but he was deemed competent after this. He was sent for a competency evaluation pretty quickly after this, wasn't he?
He was deemed competent. I think that I don't know. I mean, we're stuck with it obviously on appeal, and I'm not arguing that he was I don't think I can argue that.
Right.
I think you do have to look at the fact that his competency evaluation, basically throughout, they're saying he won't talk to the evaluators even, so we really can't do an evaluation.
He was doing with them kind of what he was doing with the officers.
And with his attorneys, frankly, also. But if you look at the diagnosis they did eventually reach, it was schizotypal personality disorder, which is basically, if you look at the symptoms in the DSM-5, it's basically schizophrenia light. And the symptoms sort of fit Mr. Parker to a T. So I think that's where his mental illness comes into play. And at one point in the evaluations, again, to the extent he was talking to the evaluators or they were able to talk to his family, one of his beliefs was that it didn't matter what he said to police because he could transport himself out of his cell at any time because he was a supreme being and had that power. So I think that plays into his understanding of how Miranda works. And, just because I can sit here and talk to you straightforward doesn't mean there's not some seriously messed up stuff going on in his head. And the officers had notice of that, frankly, even without a diagnosis. They knew that he thought he was
But getting
gone.
back to my question, can you point to us anywhere where you could say he didn't understand what was going on as it pertains to his waiver of Miranda?
Beyond what I just said, no.
Okay.
And wasn't there an exchange where the officers reviewed with him that he understood at least the words of Miranda, in terms of, there was some talk about, we know you read the dictionary, we know you understand, and this is when he was kind of pushing back. So they did at some point at least cover that part of it, understanding.
I think I don't think I can stand up here and say that he can't read or anything, that he was illiterate. So I'll concede that point.
So wasn't, kind of back to my point earlier, isn't that about all we get in the normal Miranda proceeding? We just have somebody saying, yes, I understood what you read, but we don't know that they really understood the concepts.
And I think that that's probably the bare minimum. I think that in some Miranda warnings, the officers do go in and explain a little bit more than that, whether that's required or not, whether it should be required or not. We could probably talk all day about that. But again, here, I just think that check for understanding came too late. And I want to move on to reverse.
The question, do you understand, does not increase the understanding of the defendant. It only edifies the officer. The purpose of that is just to confirm to the officer that the defendant understands, correct?
Thinks he does.
Or thinks he does. But I think it at least provides some basis later because it's the prosecution's burden to prove that he did understand.
But he said he did.
He said he did too late in this case.
Why? Why too late?
Because he had already made several incriminating statements at that point.
But there's no indication that he didn't understand or that his understanding was changed during the interim, is there?
There is no indication that he did understand either. I guess that's the problem, and it's the state's burden.
But it's only the officer who's educated by the answer.
I guess I'm not sure I take your point, Justice Wilson.
Well, you're not giving the defendant any additional information or increasing his understanding by asking him if he understands, correct?
But on appeal and in the district court, because we're kind of in de novo land on appeal here, so we're in the same position really as the district court as to the legal conclusions. It's almost not even about whether he understood or not. It's about whether the prosecution can prove he understood. And the prosecution here, because that warning came so late, I don't believe can. And I think that's probably the most satisfying argument I'm going to be able to give you on that. And I apologize if that's not sufficient.
You were about to say that you had a point you wanted to make before you ran out of time, and then we took your time. If you'd like to make your point, I'll give you that time.
As to just, may I have 2 more minutes, Justice Lugert? I'm sorry, I just really want to touch on this other issue. I'll be fast, I promise. As to the lesser included offense issue, as the discussions with Mr. Call went earlier, it's in the light most favorable to the defense. The state, I fully expect them to get up here and say, we have this video. They do have the video. I fully admit that. We have eyewitnesses.
Let me just, and we kind of highlighted, and we don't want to blend the two cases together, completely separate cases, but they are distinct in one way. Is here we have and there might be a question of who's the aggressor here, but it appears from the witnesses, Mr. Parker is in the initial altercation. He's beating him. The victim's on the ground. He takes at least a minute to walk away, go to his car, have a drink, get his gun, come back out and shoot him 7 times. Isn't that a sufficient time? That's different than the last case where it was kind of questionable how rapid the break was. But here, how is that a sudden quarrel or something where there isn't time in between the what you're complaining of in terms of what is the sudden quarrel or the heat of passion and the killing?
Well, and I think as Mr. Call said in the first case, and sorry, I'm blending them together more now too, we're talking about the difference between sufficient evidence of premeditation and enough evidence to give voluntary manslaughter to the jury.
And what's enough evidence to give here when there's that fact that he took a minute?
I don't think a minute is presumptively long enough. When you think about, and the state talks about him being the initial aggressor here, and I'm not going to say that that's irrelevant, but also this isn't like an imperfect self-defense voluntary manslaughter. This is heat of passion voluntary manslaughter. Doesn't particularly matter if he's the initial aggressor or not. They were having a fight. We have eyewitnesses, which we have to believe for the standard of review in this issue, that said they were mutually landing punches on each other. And then within a minute afterwards, Mr. Parker goes and gets his gun. We're disputing the part about the drink a little bit, I think. Whatever. And he shoots him. And I think it's a jury question whether that is sufficient time to cool off and do the, reflection for however long that takes to be premeditation, or whether that was heat of passion and he was still mad. He still had that adrenaline pumping through his body, and it was a heat of passion case. And here, as I would like to just draw the court's attention to my 609 letter, because I think we've thoroughly muddled the reversibility on this issue with the kind of moving target that we've had. But I think this case is a lot like Barrett in that the jury had a choice between intentional murder and acquittal. They were not going to acquit him. There was no way that was going to happen. So really the question was, did he have that cooling off period or not? And the jury was not given an option to find that. And for that reason, we think Mr. Parker's case should be reversed and remanded for a new trial without his statement and with correct lesser included instructions.
Just one question.
Sure.
What were the statements made by the victim that would arouse the defendant's passions to the point that he could invoke this concept?
I think in that respect, I think this case is better than the first case, because I think you had them, you had the eyewitnesses saying that they were mutually calling each other names and fighting. You have on the video even Mr. Zayad is poking his finger in Mr. Parker's face, and I think there's a case the state cites, Guevara, that says an assault is sufficient provocation. So if we have threatening words and physical actions towards him like that, I think that is at least in the neighborhood of assault. And then also I think it's important that we look at, the question here isn't if the fight itself was preceded by sufficient provocation. The question is if the shooting was preceded by sufficient provocation. And my argument, at least one of the arguments I'm making, is that the fight itself was the provocation that led to the shooting. Without
any attenuation from the time that it took him to walk and have a drink, pick up his gun and walk back and shoot the guy. And, as I'm sure the court has watched the video, it's not a pretty video to watch. That all does happen very, very quickly. The whole thing from start to finish is in less than the time I've been standing up here since my time got cut off. Thank you.
Madam Chief Justice, Counsel, may it please the court. I want to focus on one thing that counsel just said that I think solves this question of whether the voluntary manslaughter instruction should have been given, whether it was factually appropriate in this case once and for all. Counsel just said that the fight itself was the sufficient provocation. The fight itself was the sufficient provocation. If that is what they are arguing, then by all means, the state clearly has proved that this was not a factually appropriate instruction, and Judge Clapper was absolutely correct not to give the voluntary manslaughter instruction. Counsel's correct. You have a video in the record before you, and I encourage you to review that video. And what precedes the fight, she's accurately described it. There's an argument. Clearly, there's heated words between Mr. Parker and Mr. Ziade, the victim. And
Well, you can't hear the heated words. There's no audio to the video.
the testimony was
Okay.
that there was an argument between them. You're quite right on that, Justice Rosen. But they're calling each other names. That was the testimony, and they're arguing. And then you have Mr. Parker's statement itself saying that there's an argument. Arguments are not sufficient provocation. It's because that's mere words. Mere words and gestures, even the most offensive words and gestures, have never constituted sufficient provocation to justify voluntary manslaughter, much less a fight preceding a voluntary manslaughter. Also, so if that's the argument, then I think that there was absolutely no error, factual or legal, in not giving the voluntary manslaughter instruction. But I'd like to focus a little more on that because in this case and the other case earlier today, there's confusion about what the standard is, how a district court is supposed to assess whether or not a lesser included instruction is appropriate. I concede that yes, voluntary manslaughter is a legally appropriate lesser included offense of premeditated first degree murder. No one is disputing that. However, the standard that the district court is supposed to, the test that the district court is supposed to apply is laid out in KSA 223414, and that says in cases where there is some evidence, and this is the important part that this court needs to keep in mind, if some evidence which would reasonably justify a conviction of some lesser included crime, the judge shall instruct the jury as to the crime charged and the lesser included crime. Reasonably justify in this case. Let's say for the sake of argument that there had been no video in this case and that the court is relying on the testimony of the eyewitnesses in this matter to reasonably justify voluntary manslaughter instruction. I think the one witness that counsel relies on says that there was some physical altercation and there were blows landed from Mr. Ziade and Mr. Parker, that they're fighting each other. That was the testimony. And I note that that's really not at all borne out in the video. Mr. Ziade hasn't, I would characterize it as no chance at all. He's not fighting back. He's taking protective action. But disregard that video. Then I think if we have that situation where you have testimony, then that might reasonably justify a voluntary manslaughter instruction. The question in this case is we've got, and the court has seen the conflicting evidence. You have the uncontroverted video evidence, and then you have this testimony that there's a fight taking place and blows are exchanged. Well, who are you supposed to believe, a witness or your own lying eyes on that one? If the I think that it doesn't reasonably justify, the testimony of a witness doesn't reasonably justify the giving of the voluntary manslaughter instruction if you've got video evidence which completely controverts that. And just to give an example, if the witness had testified, I saw Mr. Ziade draw a gun, Mr. Parker drew first, and that's completely controverted by the video, then we wouldn't give a self-defense instruction in that case. At least I hope we wouldn't. I would like in this case also, going back, I think this case is very similar to State v. Gallegos, and the facts on that case where this court found that there was no factual support to justify the giving of a voluntary manslaughter in that case, because the evidence in the Gallegos case was that there was an argument between Gallegos and the victim immediately before the victim's death, and this court found that wasn't legally sufficient because the testimony in that case was that Gallegos went to pick up his nephew who had been slighted in some way by the victim. He drove to the victim's house, instructed his nephew to knock on the door. The victim comes out and he says that he had been messing with Gallegos' nephew. Gallegos pulls a gun and points it towards the victim's head, and when the victim tells him to calm down, Gallegos shoots him. I mean, this case it's fairly similar to that.
The video shows the victim walking away
Yes.
from the fight, right?
Yes, and like I say, I don't really want to characterize it as a fight.
I understand from whatever was happening.
As
Yeah.
Mr.
The
Parker's
physical
Yes.
encounter.
And yeah, the video shows Mr. Parker does. He basically knocks Mr. Ziadeh to the ground, and then he proceeds to just physically beat Mr. Ziadeh for I think it's about 30 seconds. Mr. Ziadeh, he eventually is pulled off. Mr. Parker is eventually pulled off by a coworker, and Mr. Ziadeh, he walks away from that. He's lost his teeth in this encounter as well. And that's when Mr. Parker goes to the car. He empties out his tea, and then he gets his gun and then walks very calmly, very coolly, very collectedly towards Mr. Ziadeh and guns him down while Mr. Ziadeh tries to run away. So I think that if this court does find that there was some sort of evidence justifying the mutual fight or that voluntary manslaughter instruction should be given, then the failure to give that instruction is harmless beyond a reasonable doubt because of the overwhelming evidence in this case. And that would be in the form of the video and Mr. Parker's own words, but most importantly because of the video. And also I would ask the court if voluntary manslaughter was sufficient, should have been given in this case, to consider the skip rule and to clarifying that either, I know that that's a more prudential application that this court has taken with the skip rule, but I would also consider that the harmlessness, the fact that the jury was given the instruction of intentional second-degree murder, and they found the elements of premeditated first-degree murder were satisfied in this case. Unless there's any other questions on that issue, I'll move on to the first issue of whether or not Mr. Parker knowingly and understandingly waived his Fifth Amendment rights. The testimony in this case at the Deno hearing, there was just one witness, Detective Sutton. He was asked, did Mr. Parker give you any indication that he was having a hard time understanding you? And he replies, no. This is on page 14 of volume 11 is what I'm reading off of. And Detective Sutton explains that Mr. Parker did not want him to read the Miranda rights to him in this case. He wanted to read them himself. He felt that having them read to him sort of belittled him. And so Detective Sutton, Detective Sanchez, they complied with Mr. Parker's request, and they gave him the Miranda rights, which are also in the record. And there's no argument that, I think that there's no argument that if Mr. Parker read these rights, then they would satisfy Miranda. So first, the officers themselves, they have no indication that he doesn't understand them. And then on cross-examination, he's asked, how do you know that he read his rights? You didn't ask him that. And then
May I interrupt for just 1 second?
Certainly.
He refused to have them read to him.
Yes.
He also refused to sign the.
Yes.
Okay.
And also that's fairly consistent with Mr. Parker's actions throughout his conduct in the case, and also when he was getting mentally evaluated. So on page 44 of the hearing, defense counsel is asking, how do you know that he read his rights? You didn't ask him that. And Detective Sutton said, we believe through his body actions and conversations that we had that he did. So again, as he's talking to him, he has no indication that Mr. Parker is confused about what's going on here. And he also later indicates one of the reasons that he didn't want to read the Miranda rights out loud is that he felt that Mr. Parker was a racist. And so he's trying to accommodate Mr. Parker. He doesn't want to upset Mr. Parker. He's trying, ultimately, he does want a statement. I think that that's undisputed. So he's, again, accommodating Mr. Parker so that he can get a statement, at least understand what happened, shed some light on this. The district court reviewed the video as well as assessed the testimony of Detective Sutton. District court found that Mr. Parker had a little more than a minute to review the advice of rights form and he refused to initial it anyway. The district court was clear that it felt the better practice would just to read him his rights anyway and then acknowledge that he understood that, but he found that this was sufficient. And if we look at the conversation itself, which you also have is in volume 16, there's ample indication there that Mr. Parker knew that what was going on. At one point in the transcript, they ask him, what do you think's going on? He says they'll probably charge me with first-degree murder. So he knows he's being investigated. He's not confused about that at all. Legally, as counsel notes in her brief, written warnings are sufficient if it appears that the defendant has read the card and indicates an understanding of what he has read. And also, on that same, I'm looking at page 8 of brief of the appellant, giving the warnings and writings alone will suffice if it is shown that the defendant could and did read the warnings and he acknowledged an understanding of them. It probably would have been better practice for the officers to ask immediately after he read these, did you understand these? But they eventually got to that, and Mr. Parker was clear that he understands everything he reads. I think that the United States Supreme Court has held that implicit waivers are perfectly acceptable in Burgrees v. Tompkins. That case had, I'd say, worse facts than this at hand, because the evidence in that case was that the defendant in that case, he was on a stiff chair that he felt uncomfortable on for about 3 hours, and about 2 hours and 45 minutes into the interview, the officers asks him, do you believe in God? And then that's where he breaks down and confesses to the crimes in that case. So, and one of the things that the Tompkins court notes is that you can tell if someone's implicitly waived their rights by the course of conduct in the interview, if they're appropriately responding, if they know the circumstances around them. And I think that in this case, there's ample evidence that Mr. Parker not only knew what he did and what he was facing, but in a sense was proud of it. Unless there's any other questions. Well, in summation, I would ask this court to affirm the district court's finding that Mr. Parker made his statement knowingly and understandingly, and I'd ask the court to affirm his convictions and find that it was not factually appropriate in this case to give the voluntary manslaughter instruction. Thank you.
Thank you, counsel.
May it please the court. Just to correct a few things that I believe I heard my colleague on the other side say. First of all, in Tompkins, I think the facts in Tompkins as far as the Miranda waiver were better than the facts in this case. They gave him a written warning. The officer read part of the warnings out loud, and there was a conflict in the record. The officer at one point said, yes, I did ask him at the end of that if he could understand. And at another point he says, well, I can't remember if I asked him if he understood or not. But at least there was some evidence in the record that that final question was asked. And I heard Mr. Obermeyer say that they didn't want to upset him here because they wanted to get a statement. And of course they wanted to get a statement. But that doesn't abrogate their responsibility to make sure that he understands what his rights are first, even if that is going to upset him. As to the lesser included offense instruction, the court knows what the standard of review is. I think opposing counsel is leaving out the part of the viewing the evidence in the light most favorable to the defendant.
I have a quick question on
Sure.
that point. In your first argument, I think you made the statement that given our standard of review, we have to believe the witnesses who testified to mutual combat. It's the state's position, I think I heard the state argue, that that would be true in normal circumstances, except if there's video evidence that completely controverts those witnesses' testimony, then we don't have to. What do you think about that?
I'm sure you're surprised. I completely disagree with that, Justice Stiegel.
That doesn't surprise me. What's your best articulation of the legal reason why why you're right in that instance.
It's the standard of review. We have the eyewitness testimony, and I bet you dollars to donuts that if we were standing here on a voluntary manslaughter conviction and I was arguing sufficiency of the evidence under these facts, the state would be saying, but the eyewitnesses said there is some evidence, there is sufficient evidence. And this is going to be more of a problem, right? As more places are videotaped. I mean, we have
What if it had been, what if we are on a sufficiency
on voluntary
standard of
manslaughter?
review, but the facts are reversed and your client was actually convicted, but you have video evidence that completely controverts the witness test, the state's witnesses. Wouldn't you argue at that point that no, the evidence isn't sufficient?
Of course I would, and I would lose.
You think you would lose?
I think I would. Yes, I absolutely think I would, Justice Stiegel.
So you don't think there's any, when we're on a sufficiency of the evidence standard of review, the appellate court has no ability to
weigh
balance
credibility?
that evidence.
I mean, you're weighing credibility of evidence, really. And that's the jury's job and not this court's job.
So if a jury chooses to believe the state's witness over video evidence that completely exonerates your client, you really think that the defendant would lose in that case?
I actually do, Justice Stiegel.
Thank you.
And with that, we would just ask this court to reverse and remand this case for a new trial, please. Thank you.
Thank you, counsel. Thank you to both of you for your arguments. The court will now take this matter under advisement.